Yes, I'm Vivian Curran. I teach in the area of comparative and international law. Actually, what I've been focused on for quite a number of years now is what I call transnational law. It's what's happening to law as foreignness is entering our courts because of globalization. So what I'm going to talk about is the Foreign Sovereign Immunities Act, with which many of you may not be familiar, but really this is a story of a statute that had a human rights gap. And over a long period of many years, the courts were able to fill this gap, and it wasn't easy. They tried one thing, they tried another thing, it didn't work. And finally, they were able to reach what I think was an excellent solution, where victims of grave violations of human rights were able to get to be heard in United States courts. And then in very recent years, some courts started taking another turn, and this is what I call the evolving genocide exception. So the courts have been creating a new exception to the statute, which isn't in the statute. And even though the Supreme Court has said, and the legislative history has made clear, that this statute is a comprehensive statute. So that's what I'm going to be telling you about. So what is the Foreign Sovereign Immunities Act? For those of you who don't know it, it is a statute that spells out when foreign states are entitled to immunity. That means that they are not subject to being sued in United States courts. Before this statute was enacted in 1976, the situation was a real mess because courts made these decisions, and they made the decisions largely based on executive opinions. Like the executive branch would say, well, in this case, this would be a problem with our foreign relations, so please do this. The courts would do it. And so it was a jumble. The Supreme Court actually used the word, it was bedlam. So in 1976, Congress passes this statute. It says it is a comprehensive statute, and it's meant to take this matter out of the hands of the executive and place it in the hands of the judiciary. And then, as recently, let's say, as 2014, the United States Supreme Court says, but really this should have been clear before, that the statute stands or falls on its text. Legislative history pretty much supports that. So, in addition to explaining that foreign states are allowed immunity in the United States, which isn't in international law a given. Actually, the point of departure is the opposite, that the immunity from suit, which is accorded to a foreign state, is a matter of comity, and the phrase that tends to be used because it's a quotation from a Supreme Court decision is comity and grace. But most countries do accord immunity, whether by statute or other means, to other states. However, there are also some exceptions to this grant of immunity to foreign states. And my entire talk concerns one such exception. This is section 1605A3, where a foreign state is not immune from jurisdiction where it has expropriated property in violation of international law. And this violation of international law has always been interpreted as violation of customary international law. And so this is the particular exception that has been the object of genocide-related lawsuits. And over time, it has undergone a series of judicial interpretations, and the latest of which have really taken it quite a distance from the FSIA's text. So initially, where a foreign state had expropriated property from its own citizens, the United States court said that this exception to immunity was inapplicable, and this was called a domestic taking. So a domestic taking was essentially an exception to this exception, and the idea was where a state did whatever it was going to do that was wrong, that was a violation of international human rights to its own citizens, the U.S. was going to stay out of it and have nothing to do with it. The U.S. courts were not going to grant jurisdiction. So the motivation for this was the idea that we don't interfere in the affairs of other states. And in addition, the other idea was that as long as a state was sued for action taken towards its own citizens, that was not considered within the purview of international law. But there was a problem with this, and the problem with this position is that sometimes what came to the U.S. courts, where victims were asking for a Foreign Sovereign Immunity decision under 1605, were victims of the most horrific human rights violations. And the courts were saying, no, we decline jurisdiction, we have no jurisdiction, even where those citizens who had been citizens of the foreign state at the time of the human rights violations were now U.S. citizens or U.S. residents. And just to put some of this in perspective, we're talking, generally speaking, about horrific acts that happened decades ago, and they're now being brought so many decades later. And why is that? So I don't know if any of you have seen the film The Lady in Gold about the Klimt paintings, but what happened is there was an issue about whether the FISA, we call it the FISA, a different FSIA, can be applied retroactively. That means it was enacted in 1976, but what about the Nazi-era takings of those Klimt paintings from the uncle of Maria Altmann? So what the U.S. Supreme Court decided, and what has been the law ever since, is that it can be applied retroactively because it's not substantive law. What we're talking about here is merely an issue of jurisdiction. So that's why all these cases have been arising since the Altmann decision, and they are arising now. The last important decision is as of 1 month ago by the D.C. Circuit. So my hope in writing this article is that there's an inter-circuit conflict now on the issues I'm talking about, and I'm really hoping to do whatever I can to influence the courts that look to each other. So one of the other things you find in areas like this one is that there are sufficiently few cases out there on this issue. It's a small issue, it doesn't arise every day, that the circuits look to each other. So, okay, so what happened was that eventually an exception to domestic takings was carved out. So the U.S. courts carved out an exception to the domestic takings exception, to the 1605 exception, and they did allow for lawsuits against foreign states where the foreign state, in the eyes of the U.S. court, had not deemed those plaintiffs to be citizens at the time of the taking. So this was where they were nominally citizens, but they were not substantively citizens. And this solution worked very well, and it solved the problem. What happened is that the Seventh Circuit created a new exception where it stopped considering victim nationality at all, and it just said that FSIA jurisdiction would be granted where the expropriation related to a policy of genocide, period. And then it also coupled this with the requirement of exhaustion of remedies. So exhaustion of remedies means that you require the plaintiff to go back to the country which perpetrated the human rights violation and seek local remedies there before you allow it to be heard in the U.S. They said, well, you know, if there is a problem with the local court decision, you can then ask to have your claim reinstated. Okay, but that doesn't work for reasons that can be explained. So, okay. So the courts may have been very well-intentioned and be well-intentioned in developing this new genocide category, which is nowhere to be found in the 1605A3 statutory language. But one of the problems is that it leads to precedents that trivialize the concept of genocide. The courts are now going so far as to say that expropriation of property is itself genocide. And the concept of genocide already has been subject to considerable politicization on the world stage. Worse, the requirement that
Vivian?
Yes.
The mic, I think, is not working.
Thank you. And even worse, the requirement that you couple genocide with a supplementary requirement of exhausting your remedies locally, it means that effectively plaintiffs being sent to those foreign courts are going to have their cases dismissed. They're suing the foreign sovereign in that foreign sovereign state that perpetrated the violation of rights. So their chances of succeeding there are very slim. And then the chance of being reheard in the United States is also extremely slim, because the bar for being heard where you have a foreign judgment, the dismissal of a case in a foreign court where the foreign sovereign has a foreign judgment there, means that the United States will have to pretty much condemn the judicial system of a foreign country. And that bar is extraordinarily high in the United States. And it would involve a United States courts offending the contemporaneous foreign system. Whereas, in fact, most of these foreign sovereigns in these cases of genocide that happened many years ago themselves have nothing to, they declare that those acts were abhorrent, and the government of their own country during those years was an abhorrent government that they have nothing to do with. So for the United States District Court to hear such a case is not an offense to the contemporaneous government, but for the United States to say that a foreign judgment by this government, now in place in the local foreign sovereign, is an offensive matter. So they have a very small chance of prevailing. And what happened was that the exhaustion requirement arose from 1605's reference to international law. And 1605's reference to international law became confusing to the Seventh Circuit because of its misinterpretation of the Restatement Third of U.S. foreign relations with respect to the exhaustion of local remedies in domestic courts. So customary international law does not have a requirement for exhausting local remedies unless the parties are in front of an international tribunal, and that is for very good reasons. And so I was working on the Seventh Circuit case at the time that the Restatement Fourth was being drafted, and I was a member of what's called the Consultative Members Group of the Restatement Fourth at the time that it was being drafted. And this matter was a very, very small matter to the drafters of the Restatement Fourth, but I was able to bring it to their attention, and now the Restatement Fourth has rectified what was essentially silence on the part of the Restatement Third. The Restatement Third drafters knew exactly what customary international law required, and if you read the Restatement Third, it is absolutely correct, but it is not, it doesn't spell out that customary international law only requires exhaustion of international tribunals. It gives examples that make that clear, but it doesn't actually spell it out. Now the Restatement Fourth does. So, okay. So the issue of citizenship arose in first arose in a case where 3 current and 1 previous Iranians sued the state of Iran for property expropriation that concerned real property, rental monies, and pensions. And the court said that the law of nations, which is an older term for customary international law, does not prohibit a government expropriation of the property of its own nationals. So it said this because it said governmental expropriation is not so universally abhorred that its prohibition commands the general assent of civilized nations. And customary international law is in fact distinct from what we otherwise call international law by generally referring to matters such as international human rights. And so that case became then the model for future cases for quite some time. And in a later case, the Second Circuit held that the law of nations had not been violated in a case where a victim of Nazi dispossession had sued. And it cited, so now we are in the 1970s or the 1980s, and this court cites a 1937 treatise on the law of nations and another one dating to 1826. And it said that the law of nations wasn't violated on the reasoning that international law is a law of states and not of individuals. So that had been accurate at the time of the law being cited. It was accurate up to the Second World War, but international law was changed by the Second World War, and in particular by the Nuremberg trials, or the principles that were laid down there, or more precisely by the London Charter that had preceded those trials. So one of the great internationalists wrote in 1950, "There is no rule of international law which definitely precludes individuals and bodies other than states from acquiring directly rights under or being bound by duties imposed by customary or conventional international law." So by the time of the statement hadn't been accurate for about 3 decades, yet once our courts say something, they have a precedential effect. Almost 10 years later, the Fifth Circuit cited that case in another case called de Sanchez as persuasive authority for the same principle. So it did recognize that the international law had been changing, had been started to encompass individuals in international human rights cases, but it said that that standard did not encompass property expropriation. And I do want to stress that the 1605 exception, which is what we're talking about under the FSIA, because it's not a criminal statute, the only way to get jurisdiction in the courts is to claim a tort and property expropriation. The court said the standards of human rights that have been generally accepted and incorporated into the law of nations are still limited. They only encompass such basic rights as the right not to be murdered, tortured, or otherwise subjected to cruel, inhuman, or degrading punishment. So they don't encompass expropriation of property. So one of the things that plaintiffs have argued is that jus cogens violations, jus cogens refers to the most horrific violations of human rights, that they constitute a waiver of immunity on the part of foreign sovereigns. And there is another exception under the FSIA that says that where a foreign sovereign has either explicitly or implicitly waived its immunity, then the courts of the United States do have jurisdiction. So plaintiffs argued that such violations constitute an implied waiver. So the most famous case dealing with that argument was the 1994 case of Prince versus the Federal Republic of Germany. And this case involved a plaintiff who at all times relevant to this entire case had been a US citizen. So he, as a child, had been living in what today is Slovakia at the time of the Nazi invasion. And because his family was Jewish, they were sent to concentration camps, even though the whole family had US citizenship. His parents and sisters were murdered, his brothers starved to death, and the plaintiff himself experienced all of the horrors that you can possibly imagine that were associated with the Holocaust. After the war, because he was a U.S. citizen at all times, he wasn't eligible for reparations from Germany under Germany's post-war laws. And he also wasn't entitled to any compensation that he might have had under international law as a refugee because he was a U.S. citizen. He was repatriated to the U.S. When he survived the war, but he wasn't considered a refugee. So the district court had held there was an implied waiver of immunity even more strongly because this plaintiff was an American citizen, but principally it said because the Federal Sovereign Immunities Act has no role to play where the claims alleged involve undisputed acts of barbarism committed by a one-time outlaw nation which demonstrated callous disrespect for the humanity of an American citizen simply because he was Jewish. The court cannot permit such a nation, which at the time of these barbaric acts were committed, neither recognized nor respected U.S. or international law, to now block the legitimate claims of a U.S. citizen by asserting U.S. law to evade its responsibility. To allow otherwise would create a severe imbalance in the reciprocity and mutual respect which must exist between nations and would work an intolerable injustice. But the appellate court reversed. It found that the plaintiff had not satisfied any of the FSIA exceptions to immunity. And indeed, if you look at the exceptions to immunity, it had not satisfied 1605A3. And if you look at the implied waiver to immunity, that implied waiver said the appellate court needed to include some kind of intention on the part of the sovereign state to waive its immunity. Okay, so there was an impassioned dissent to this by Judge Wald, which went very much along the lines of what the district court had done that I read to you, but the majority said no. Okay, so so this line of reasoning continues. And the restatement fourth endorses this, or rather reports this, that waiver of, implied waiver will not be found under the FSIA where there has been a jus cogens violation. Okay, so at this point, or at the next series of cases, where the solution was found, that was a great solution in my opinion, is the doctrine of, what I call the doctrine of substantive citizens' rights. And this found a way to do justice within the language of the statute without departing from 1605A's intention, in my view, without being a judicially created exception that had no basis in the statute. It had a basis in the statute, and yet it closed that human rights gap. So the courts didn't find that jus cogens waived immunity. What they did, though, was consistently with the legislative history of Congress, which said that it intended to prevent discriminatory takings, they started to apply concepts of what citizenship was from other areas of the law. And what they said was that where a country had stripped a minority population or the victim of its civic and political rights, that did not constitute full citizenship in the eyes of the United States. And there were definitions from other areas of the law, such as immigration law, where the United States had been using that test. So then you had a series of cases which really seemed to be able to accommodate the situation quite well. You had the case of Cassirer, which concerned the forced sale of property by the plaintiff's Jewish grandmother as she had to flee Nazi Germany, and the forced sale of art. And the court said that at the time, 1939, she was not considered a citizen of Germany. Okay, so Then there was a case of Dispossessed versus Republic of Hungary, and the court cited with approval the lower court's finding that the Hungarian government at the time of dispossession of the plaintiff had not considered the plaintiff who was Jewish as a statement. And the court concluded that even if the plaintiff still considered herself to be a Hungarian citizen in 1944, it is clear that the government of Hungary thought otherwise and had de facto stripped her and all Hungarian Jews of their citizenship rights. Okay, so the problem is that the interpretation didn't stop there. And I think from there were some steps backwards. The new turn of affairs starts in the Seventh Circuit with a case called Abelez. And for peculiar procedural reasons, the Abelez case is reheard under the name of Fisher. So the Abelez court ruled that a context of genocide obviates the need for any judicial inquiry into citizenship. So they stopped the inquiry into citizenship where the taking, the expropriation, has been committed in a context of genocide. So here, just like in some other cases, the plaintiffs were Hungarian Jews. Here they had been dispossessed of the last remnants of property that they owned on the train as they were being deported to Auschwitz. And so they made claims against the state of Hungary. This is a class action suit. And the court said plaintiffs' allegations of these expropriations as an integral part of the overall genocidal plan allege violations of international law, notwithstanding the domestic takings rule that would apply in most other circumstances. Okay, so because there were so few cases in this area, other circuits start referring to Abelez. Okay, and there was a completely remarkable case which really applies the Abelez rule. This is where Armenians sued the Republic of Turkey for property confiscated from Armenians during the genocide of 1915 against Armenians. But what is really astonishing about this case is that court takes pains to say that while in Abelez, the plaintiffs were Hungarians, although they may have been stripped of some of their rights, so we're no longer Hungarians. In this case, the Armenian citizens were full-fledged citizens of Turkey. Now, I have to ask you, how can it be that they're full-fledged citizens of Turkey if at the time, being Armenian subjected you to death by virtue of being Armenian? But the court makes that finding. The court said, contrary to Abelez, our plaintiffs were full-fledged Turkish citizens, yet because this is a context of genocide, we say the domestic takings exception doesn't apply. So this is a true application of the genocide exception of Abelez. Okay, so the problem, though, is that they Abelez couples this with the exhaustion requirement. But let me just mention that in Washington, D.C., there's a case called Simon versus the Republic of Hungary, which is factually just the same as Abelez. And it goes a step further. It says that the expropriation is itself genocide, and it really emphasizes that. It emphasizes that in contrast to Abelez. It's not even talking about a policy of genocide, we're talking about expropriation constituting genocide. The 11th Circuit has indicated an inclination to apply the genocide exception and also to impose the exhaustion rule. So you might wonder why this is so problematic. And I have given you some indications. So genocide is a term that was coined by a man called Lemkin. And he defines it as the aim of annihilating the groups themselves as being directed against the national group as an entity. Actions involved are against individuals, not in their individual capacity, but as members of the internal group. So he spent his adult life after the Second World War to try to get the UN to adopt the Genocide Convention, which it did in 1948. And it lists genocide as any of the following: acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group, killing members of the group, causing serious bodily or mental harm, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction, imposing measures intended to prevent births within the group, forcibly transferring the children of the group to another group. Okay, so today, increasingly, people who work in the field of international rights are criticizing the politicization of the concept of genocide, the trivialization of the concept. And we know that the crime itself, as it has been described, as I've just described it to you, has not been eradicated in the 60 years that have followed the legal enactment of the Charter. And so for this reason, how we define the term continues to be crucial. And so it's quite problematic for judges in the United States who created the new genocide exception, however well-intentioned they may be, to dilute its meaning through case law holdings that then have precedential effect, through dicta that will have precedential effect, and which will have unintended consequences because of the precedential authority that these cases represent. So this new genocide exception represents a judicial interpretation that doesn't have a basis in statutory terms, which is supposed to be of a statute that is a comprehensive statute, and it also has dubious interpretations in international law. So the exhaustion requirement, exhaustion of local remedies, was intended only to apply to international tribunals because it originates as a way for states to protect their citizens in front of international tribunals. So it's a state that goes to an international tribunal to complain to another state. It starts out being for diplomats who have been offended, against whom a tort has been committed. So you may all know the French ambassador Kane story. You remember your tort law from first year, but whatever. So France should be able to complain about the U.S. treatment of its consuls before an international tribunal. We are in an era of international tribunals. But the idea for the international courts is also to retain their authority. And so to retain the authority of the signatory states who have signed on to whatever treaty it is that has given the international court its jurisdiction and its power, the idea is that the victim should try first to exhaust her local remedies in the foreign state. And if that's not possible, then her state can go to the international tribunal. And that is what the restatement of third was talking about in the section that the Seventh Circuit in Abeles, so the Abeles case is the district court case, and the Fisher case is Abeles, heard under this different name in the Seventh Circuit. So they all cite to the restatement third for their support, but they're quoting cases that the restatement third is offering as illustrations. And those cases involve diplomatic protection. The most famous case is Interhandle, diplomatic protection before international courts. So similarly, the exhaustion requirement serves that important goal that I just mentioned, but only before international tribunals. So the restatement third doesn't explain this. Now the courts who apply the restatement third incorrectly interpreted and customary international law incorrectly interpreted make no reference to the fact that they are domestic courts and not international tribunals. Okay, so the one case that exists where the plaintiff did go to the local court to try to exhaust remedies was the Appellate case after the Seventh Circuit affirmed the lower court. So those plaintiffs, no longer a class action, only one plaintiff, because class actions don't exist in most parts of the world, so you can't have a class action suit. And you have to, in many countries, actually deposit a fair amount of this amount of money you are claiming in your suit. But in any case, one of the plaintiffs, the named plaintiff, went to Hungary to sue the Hungarian government for what they had done to her, what had been expropriated. Hungarian government dismissed the claims. They said, you have no documentary evidence to present to the court of what we expropriated from you, so we really have to dismiss this case. We have no other choice. So documentary evidence with respect to what was taken when you were on the train station on the way to Auschwitz is, of course, difficult to get. And for any of you who have read Susan Faludi's book, In the Dark Room, you can get an idea of how difficult it is to get any archival information in Hungary at all concerning those years. So the plaintiff has come back to the United States and is now in the process, these are all really evolving cases, of asking the court for a rehearing. But to get a rehearing now will mean that the U.S. District Court will have to say that there was something intrinsically unfair, no due process, something constitutionally wrong with what the court in Hungary did. That bar is extremely high. I have been involved in cases against sovereigns where their judicial system was truly just absolutely impossible. And the courts, great courts, courts will just not say that. To get a court to say that is extremely rare, extremely hard. Okay, so the rationale for the Seventh Circuit to apply the exhaustion requirement was comity. So it's a matter of prudential comity to go back and go locally to get your to try locally in Hungary. But actually, comity militates exactly in the opposite direction if you think about it, because the state of Hungary today repudiates the state of Hungary under Nazi occupation in 1944. It does not, at least officially, in any way endorse what happened. So for a U.S. court today to hear such a case would hardly be, or should hardly be, offensive to the state of Hungary. On the other hand, for the United States today to refuse to enforce the dismissal, the res judicata effect of the Hungarian judgment could involve a much more serious comity offense. So the D.C. Circuit, after first citing to Abeles and imitating Abeles, has now changed its path. And this in part due to the restatement force in a wonderful decision, two wonderful decisions now, they have said that the courts should hear these cases and that there is no exhaustion requirement. And it's very much my hope that the fact that the D.C. Circuit is an influential circuit and that it is now overtly repudiating and separating itself from the Seventh Circuit will be influential possibly on the 11th Circuit. The Second Circuit, which is a very important circuit for these kinds of cases, has decided to wait until I can't remember what it's waiting for. It's waiting for something before it decides. So I'm very much hoping it will follow the D.C. Circuit and reject the Seventh Circuit. But we just have to wait to see. The one thing, though, about the D.C. Circuit is that it continues to equate genocide with expropriation with genocide, which I consider unfortunate. The last case it decided in this respect was just about 1 month ago. So I think I'm going to end there. There is now an inter-circuit split. I think that the new exception was an unfortunate one in light of the fact that the courts had really struggled but worked out the international human rights gap of the FSIA. So I'm hoping that possibly they'll get back on track, or that if necessary, the US Supreme Court will resolve this inter-circuit conflict in favor of, at the very least, the way that the DC Circuit has. And I'm very happy to take questions from you if you have any in the time that remains.
Yes, please, if there are any questions or comments.
Yes, Rana?
So you mentioned, that perhaps other circuits will defer to the DC Circuit since it's such an influential court, or perhaps the Supreme Court
Yes.
will clean this up. I noted that you didn't hold out, or you didn't mention any hope that perhaps Congress would act, and is that because Congress is so dysfunctional now, or because it's so hard to get Congress to act on anything, or is there some other reason why you don't float that out as a possible
Yes, I didn't mention this, but there have been, and I don't in the article either, there have been hundreds of bills in Congress that have come to nothing on these matters. Just so many. There have been some amendments to the FSIA, but very, very unlikely, in my opinion, that this kind of thing is going to come from Congress. Yes.
A more basic question, in a way, that there is a tort exception, as I understand it, in the also. And genocide clearly would be a tort.
It would.
But the tort exception only applies to torts that occur in the United States. And so I find it kind of curious that if you are subject to genocide, and your family is killed, and $100 is taken from you, sue in the U.S. courts for the $100, you can't sue for the grosser violation, which is genocide itself. And that just seems like a sue something like that. Second question is, when you say that there are courts that say that nationalization is itself genocide,
Expropriation.
expropriation is itself genocide, irrespective of the context, right? I would assume that those cases are cases where the state that's doing the expropriation is a state that is not favored by the United States. And I think one of the problems in this whole area is that once you allow an exception to immunity, it gets interpreted in a very political way, where, you allow lawsuits against states that don't favor, don't allow lawsuits against states that do.
Of course, some of the suits that can go forward have been, they've vacillated with respect to some states, like Hungary, like Germany. So when you say the states, do you mean the states at the time of the expropriation? Or the states, the contemporaneous state that's being sued now?
I would say the state that's being sued now, if they have friend relations with the U.S. government, like the Germany case, even though there was a very sympathetic claim, the courts say, well, we don't want to bring Germany into our cause, where if it's Iran or North Korea or Cuba, they will bring you.
So I have to say that I have not seen that kind of politicization so much here. You do in other areas, but one thing that your comment really does signal is to what extent should foreign relations have a role to play? And some of the early cases after the enactment of this statute involved executive statements of interest. And I think that some judges who were in the minority, who tended always to be in the minority, said the whole point of Congress was to take the executive out of this and really to take politicization out of this, to just leave it in the hands of the courts to decide based on the statute and the precedents. And that has not happened. So statements of interests are being filed, and they are being taken into consideration. The courts continue to say, well, we are certainly not bound by this, but they do take them into consideration, and sometimes heavily. So to that extent, there is a politicization. I will say this, that in the latest case, the latest case that was decided a month ago by the D.C. Circuit, the court noted that the executive branch had filed a statement of interest that was just a general statement that the U.S. government tries to protect victims of the Holocaust. That was Hungary, even though the executive branch certainly has made a lot of friendly approaches to this government in Hungary. Yes?
Does this typically, the case law pretty much surround Holocaust victims? You did mention the Armenian. Like, is there any more modern?
There is a lot of it has, but there's now a case that I'm also involved with against Germany for a tribe in Namibia, and this was a real pre-Holocaust Holocaust that occurred at the end of the 19th century, beginning of the 20th century. That was more horrific than anything you could imagine, except, the Holocaust was too. I mean, the things that were done there were just, nobody in the West heard about this. And in part because survivors didn't write about it. It was passed down through oral lore. And there are survivors of this tribe who are now suing under the FSIA. And that's the Second Circuit, and we'll see what happens. So, but these are, what I'm looking at are genocide-related cases.
So I'm thinking specifically of the potential in the future, for example, Rohingya, because I suspect that's going to be found to be genocidal, or something like Khmer Rouge or Rwanda, this kind of more modern.
Absolutely, absolutely. This really opens a lot of doors. I mean, Altman did that Maria Altman case, and absolutely, yes. Yes.
Vivian, so you're a law professor writing to try to affect some real change among the circuits. And I know as a student of civil law, you've thought about the contrast between the relationship between legal academics and the judiciary in France, say, and that in the United States. And I was just curious what your sense of your chances are.
I'm really hopeful. Actually, the lower court in Simon cited to a former article I wrote in which I was really critical of this, and that case, which has now been reversed, cited both to my article and to the restatement fourth, explaining why they were rejecting both. So, they're reading me. And the D.C. Circuit, which reversed it, didn't cite to me directly, but used my arguments. And in fact, it was the first court ever in all of these cases to explain that the net effect of exhaustion was essentially res judicata when the local court in the other country dismissed. So I'm hopeful. I really am hopeful. And I think these are the kinds of cases that do go up to circuit courts, and the higher the court, the more the chances that they will read law professors. And the other reason I do this is because the big problem here, as I see it, is that the judges are not familiar enough with international law, international customary law, and they need to be. It's really important. And so that's been one of my objectives since I started doing what I call transnational law. That's been a major objective of mine, is just to get both students and judges more familiar with what up to now has been very unfamiliar territory, and things they don't want to touch, they don't really like looking at, and with things that are foreign.